In the mid-2000s, television broadcasting was switching from analog to digital. Consumers who didn't want to buy new TVs could install digital converter boxes that would decode the digital broadcasts for their old sets. Microgem vs. Homecast features two companies that tried to get into this market and ran afoul of an ambiguous choice of law clause. Microgem was a United States distributor of electronic products. In 2007, Microgem entered into a contract with the South Korean electronics manufacturer Homecast, under which Microgem would act as a sales agent to sell Homecast's digital converter boxes to United States distributors. This contract contained a clause stating that New York law would apply to all contract claims. Homecast delivered 34,000 boxes to Microgem. Microgem claimed that the boxes were defective and refused to pay the outstanding balance. After failing to resolve the dispute, Microgem sued Homecast in New York State Court. Homecast counterclaimed and removed the case to federal district court. The parties disagreed about what law governed their contract. Microgem argued that the contract should be governed by the Convention on the International Sale of Goods. Homecast argued that the 2007 contract should govern, and that by including a choice of law clause naming New York law, the parties had agreed to opt out of the convention. The court considered the parties' cross motions for summary judgment and determined what law to apply to the contract claims.